welcoming all of you online and here in person to the 6th edition of Washington Arbitration Week. It's been an incredible journey over the last 6 years, starting in COVID, and now we're here in 2025, getting a great response from all of our sponsors and supporters, and as well as an incredible group of moderators and speakers at all of our panels. And just wanted to say thank you to all of you for the efforts that you put in and the contributions you've made. We're here at BatesWhite's this afternoon for our next couple of panels. And apropos to being here at BatesWhite, our topic concerns valuation. And we have an excellent moderator. And let me introduce you to, let me make sure I've got it here. Sara Marzal, who's agreed to moderate this panel. And she is legal counsel at ICSID on the case management team there. That's, for those of you who don't know the acronym maybe, the International Center for the Settlement of Investment Disputes. This is a role she's had since July 2015. Previous to that, she was at Clifford Chance, Chadbourne & Park, Arnold & Porter here in DC, as well as Uria Menendez in Spain. And she served, previous to that, IDB's Trade and Integration Sector and the WTO Appellate Body Secretariat. She's an LLM grad from Georgetown, which puts her at the top of all of our estimations, I'm sure, as well as SID with a law degree. And she's admitted in both Spain and New York, and she is our moderator today. So I'll pass it over to Sara, but before I do that, maybe we'll ask Carolyn just to come up and give us some welcome from BatesWhite.
Good afternoon, I'm Carolyn Berry. I'm a partner at BatesWhite Economic Consulting, and just a little bit about our firm. We have 400 employees, and they're all located here in Washington, D.C., and we do work across many practice areas. Again, thank you for coming today. And I'll say one housekeeping item. The restrooms are behind these doors behind me, if so everyone knows that. And with that, Sara, I'll pass it to you.
Thank you very much. Thank you all for joining this discussion today on the valuation of damages in investor-state arbitration in the era of climate transition. So let me begin by saying something that is quite clear at this point, that is that energy transition is happening at an extraordinary speed, reshaping both our markets, but also the legal landscape of international arbitration. I want to give a few numbers to give you an idea of the magnitude and the speed of the transition. So according, for example, to the International Renewable Energy Agency, in 2024, renewables accounted for around 92% of new power generation capacity. And according to the International Energy Agency, in 2025, capital flows to energy sector are set to rise to $3.3 trillion. Out of this 3.3, 2.2 is going collectively to renewables, nuclear, grids, storage, low emission fuels, efficiency, and electrification. Twice as much as the 1.1 trillion going to oil, natural gas, and coal. Meanwhile, the International Energy Agency is projecting that global oil demand will peak before 2030. From a climate perspective, the science is clear. The Intergovernmental Panel of Climate Change emphasizes that every fraction of a degree matters, and that in order to achieve the 1.5 degree goal of the Paris Agreement, global emissions have to be cut by 50% by 2030. And states are responding to this challenge with ambitious climate policies, whether it be reforming subsidies to phasing out coal, or adopting carbon pricing, or committing to net zero targets. All of these policies, while necessary, also have implications for investors. Some projects might become uneconomic, some assets might become stranded, some profits may vanish. And to add to this shifting landscape, the International Court of Justice issued just this July 2025 a landmark advisory opinion that I'm sure is going to have important implications in investor-state arbitration. And I'm just going to name a few of them as an example. So first of all, the ICJ addressed the relationship between the climate change treaties and other sources of international law, and clarified that all of these sources need to be interpreted in a way that support each other, so a systemic interpretation. On the other hand, it clarified that states' conduct in relation to fossil fuels, will be the exploitation or consumption, so granting of exploration licenses or subsidies, etc., may constitute an international wrongful act attributable to the state. And also that the state's failure to regulate private actors and the in limiting the emissions of these private actors can also constitute an international wrongful act. So these findings may suggest that investor tribunals will need to assess whether states in their acts or failure to act with relationship to fossil fuels investments may constitute whether they constitute a violation of the state's international climate change obligations in light of the advisory opinion. And this may have important implications not only in the issue of liability, but also in the assessment of causation and damages. So all of this raises very new and complex questions from what method of valuation, how should tribunals assess claims for stranded assets, or how should damage experts integrate in their valuation models issues like carbon pricing or foreseeable regulatory changes or shifting demand, to how tribunals should weigh investors' rights versus the state's right, or now we could say duty, according to the ICJ's advisory opinion, to act for climate change. So to help us tackle all these questions, we have here a very distinguished panel. And I'll start by introducing Kenneth Figueroa, who's a partner at the International Litigation and Arbitration Department at Foley Hoag, and chair of its Latin American practice. He's a leading, as many of you will know, leading expert in investor-state arbitration. His practice focuses on international dispute, but not only investor-state matters, also commercial arbitration and sovereign representation. And Kenneth will guide us through the legal foundations of today's topic and the possible impact of the ICJ advisory opinion. But we also are joined by well, we were supposed to be three, but Pablo Spiller in the last minute had to cancel because he was not feeling well, and we wish him speedy recovery. So we have now today two renowned specialists in damages valuation for energy projects in ISDS, who will discuss practical challenges and methods for assessing damages in fossil fuel investments under climate transition scenarios. Let's begin here to my right. I have Glenn George, partner at BatesWhite Economic Consulting, where we're here today. Glenn is an engineer economist and expert witness with extensive experience in energy and infrastructure disputes, including before ICSID and the ICJ. He has advised on valuation risks and regulatory matters across power, oil and gas, and utilities, and served as lead expert in multi-billion-dollar cases. Glenn brings deep expertise in stranded assets damages and the impact of climate-driven regulatory change. Further to the right, we have Laura Smith, who's a partner at HKA. Laura is a certified valuation analyst and certified fraud examiner with over 20 years of experience in complex damages and valuation analysis. She has served as an expert witness in major international arbitration and investor-state disputes with damages, obviously, specializing in contract, treaty, and intellectual property claims across multiple industries. And finally, here to my immediate right, we have David Weinstein, who at the end of this panel will give a short presentation on a related topic, which is the campaign for greener arbitration. David is an associate attorney at the international boutique Lewis, Baach, Kaufmann, and Middlemiss in New York. His practice focuses on international arbitration, litigation, and human rights. As fluent in French, Arabic, and Spanish, and he previously worked in Paris and frequently in the Middle East. He's the secretary of the Global Steering Committee of the Campaign for Green Arbitration and has also participated in UNCITRAL Working Groups 2 and 3 on dispute resolution and ISDS reform. So with that, we will begin with a 15-minute presentation by Ken, who will explain the legal foundations of how ICSID tribunals should approach causation and quantum of damages in light of the state's climate change obligations, the regulatory trends, and the ICJ's advisory opinion. Ken, the floor is yours.
Thank you, Sara. Can everyone hear me? Yeah, okay. Thank you, Sara. Ian and Jose Antonio, thank you for the invitation, and everyone at Washington Arbitration Week. It's really an honor to be here in this really distinguished panel. I was mentioning to someone that this is the second conference, only the second conference I've been to, where they have a damages topic on the first day. As someone who does a lot of damages in investment arbitration, it's nice to finally get my time in the spotlight on the first day and not have to wait till the very last day and have to rush with the chess clock running. It's good also to see such valuable colleagues here on the panel and in the audience as well, with whom I've worked. So very nice to be here today. So as Sara said, yes, I'm going to discuss an overview of kind of the legal landscape with respect to environmental regulation and climate change policies, which, as Sara has mentioned, is something that's been going on really for decades now, right? I mean, I think, a major UN framework convention on climate change occurred sometime in the 90s. 165 states were parties to it. It was followed by the Kyoto Protocol, the Rio Declaration, the Climate Change Agreement. This is a problem that the international community has seen for decades. And despite some naysayers, some of whom may work down the street, climate change is real. And the efforts we're seeing on an international level it reflects an intent by the international community to try and face it and to try to remedy it, both for this generation and future generations. As Sara mentioned, most recently there's this ICJ advisory opinion, which I'll get into detail a little bit further on, but it's fundamental in that it declared very clearly that states have a customary international law obligation to comply with climate change policies and environmental regulations in order to prevent further environmental harm. And we've seen the impact of climate change and environmental regulations already in ISDS for decades as well, right? Modern investment treaties include express carve-outs for measures related to environmental policies. And this was meant to ensure that states limit their liability to foreign investors as a result of climate-related policies, and in part a reaction to certain tribunal decisions which states felt did not give proper deference to their policy decisions in the environmental sphere. But of course, these carve-outs only apply to a limited number of the more than 2,600 international investment treaties worldwide. And on the other end of the spectrum, we've seen examples of states such as Spain, Japan, Colombia, the Netherlands, and others who, in their effort to implement policy changes in order to comply with their Paris Agreement obligations, with their international obligations, have been faced with investment treaty claims of millions of dollars because of their climate-related policies, particularly in their energy and mining sector. And we'll continue to see these claims. We see them every day. There's one pending right now at ICSID, registered in 2023, AET versus Germany. It's under the Energy Charter Treaty, in which a Swiss investor in a coal plant seeks damages arising from Germany's coal phase-out, a phase-out implemented in connection with its climate change obligations under the Paris Climate Accords. So there's something that's continuing we may see, and we will definitely see more of in the future. These types of cases raises the question that we're trying to address in this panel. In light of the state's climate change obligations and the increasing foreseeability of climate-driven regulatory shifts, how should ISDS tribunals approach questions of causation and the quantum of damages, and also liability? In my view, tribunals should give due import to the complicated issues involved in climate change, taking into account the competing obligations of the state vis-a-vis the environment on the one hand and investor protection on the other. And they must give deference to sovereign decisions in this space. They should also carefully assess that any damages carefully considers causation, assumptions of risk, and careful valuation methods. That hasn't always been the case. As an example, I'll discuss a controversial case many of you may be familiar with, Rockhopper v. Italy, issued in August 2022. This is an ICSID case under the Energy Charter Treaty in which a UK-based investor sued Italy due to Italy's failure to award it an exploitation concession of an oil and gas field located off the coast of Italy. Now, since 2010, before the investment was made, Italy had already adopted a ban on offshore drilling projects within 12 nautical miles of its coastline. But the law was amended to grandfather in companies that had submitted applications for concessions prior to 2010, which included the claimant. And subject to this loophole, Rockhopper submitted its environmental impact assessment, which the Ministry of Environment approved in 2015. However, in the interim, the Italian Parliament adopted a law that closed that loophole, creating a full ban on offshore exploration. The tribunal found that the approval of the environmental impact assessment triggered claimants' right to a concession, and that Italy's actions constituted a direct unlawful expropriation. Now, they noted that Italy had relied on the precautionary principle, which, as many of you know, is that even though there may not be concrete evidence with respect to harm, if there is a danger of harm or permanent harm, states have the right to implement measures in order to prevent it. The tribunal interestingly noted that while Italy could rely on it once it approved the environmental impact assessment, it no longer could rely on the precautionary principle. And the tribunal noted that the ban was a sovereign right, but that did not mean that it was exempt from compensating investors. And it also rejected a police power doctrine defense, stating that that police power is not absolute. On damages, the tribunal rejected all the valuation models submitted by the parties. Claimant presented a DCF valuation of 275 million euros. The tribunal found that because there were no historic cash flows, the DCF might be speculative. Italy, on the other hand, presented market-based and sunk cost approaches for a valuation of between 2 to 13 million euros. The tribunal also rejected these as not being appropriate because it saw the project as a little bit further developed than what would be appropriate for these types of methodologies. Now, with no damages valuation before it, and having rejected all of it, one would think that that should be the end of the analysis, right? There was no the burden of proof had not been met, and there should be no damages. No, that's not what happened. Instead, the tribunal used an old DCF model that was in the record, prepared by claimant when it decided to acquire the project several years before, which valued the project at 104 million euros. Now, to the tribunal, this offered a balanced approach because claimant needed to convince its shareholders that the acquisition was worthwhile, but also had to avoid inflating the price. So the tribunal saw it as a balanced approach. And based on this, it awarded $184 million, that precise amount, plus decommissioning costs and an interest rate it determined at its discretion. Now, in my view, the Rockhopper award presents several problems. While the tribunal gave lip service to the state's sovereign right to protect the environment, it clearly did not give much deference. It ignored the risk assumed by the investor despite the ban on offshore exploitation and the lack of any express commitment that the loophole would not change. Significant for damages, the tribunal kind of went rogue. Neither party relied on the old DCF model for its valuation. And that model certainly did not consider pertinent inputs related to climate change because it was done solely for internal purposes of the claimant when it acquired the investment. Now, the Rockhopper Award was controversial because it reinforced concern by many states of the Energy Charter Treaty's protection of fossil fuel investments and the fact that tribunals would enforce those protections despite changing climate change obligations. Shortly after the award, Spain, Netherlands, Poland, and France announced their intention to withdraw from the ECT. The award was ultimately annulled because of issues concerning an arbitrator's failure to disclose a criminal conviction in Italy that had been quashed. Claimant has registered a new arbitration, so we'll see how the claim fares now. Now, having seen what I consider as a bad example, the question then arises, how should ISDS tribunals factor climate change obligations when assessing damages? Now, climate obligations are just that, obligations, confirmed as such by the ICJ in the recent advisory opinion. And thus, those obligations should be given significant weight when considering the circumstances of the case. Odyssey Marine Exploration versus Mexico is relevant in this regard. This is a NAFTA case, an UNCITRAL, filed under UNCITRAL rules, in which a U.S. investor brought a claim on behalf of itself and its Mexican operating company arising from the denial of an environmental permit for exploitation of a phosphate deposit off the coast of Baja California. A majority of the tribunal found that the permit denial was arbitrary and thus a violation of the minimum standard of treatment. On damages, the majority correctly, with respect to this, dismissed the DCF approach presented by claimants because there was no operational track record. And the majority adopted the sunk cost approach and awarded $37.1 million, a significant discount from the original damages claimed. Now, what's relevant about this case is the dissent by the state's appointed arbitrator, Philippe Sands, who many of you may be familiar with or know. In that dissent, he stated the tribunal should have taken into account evidence of potential environmental harm and the state's environmental obligations. In his words, the Vienna Convention on the Law of Treaties requires the interpretation of the treaty of NAFTA to take into account any relevant rules of international law applicable in the relations between the parties, a formulation which includes treaty and customary obligations. In the present case, the relevant rules which are applicable include customary obligations on the protection of biodiversity and the marine environment. These obligations can be found in treaties such as the 1992 Convention on Biological Diversity and the UN Convention on the Law of the Sea, and have also been found to exist in customary international law. Those customary obligations include the obligation to protect and preserve the environment in a manner that is consistent with a precautionary approach, again, the precautionary principle. Now, I agree with this statement, and that's, I think, what makes the case relevant. Now, Sands was referring to liability, but the same point of view should be adopted for damages. To be clear, I am, and no one is saying, or should be saying, that climate change obligations are carte blanche. There may be circumstances in which a state should compensate an investor for losses resulting from climate change regulations and policies. But I think, given the level of knowledge of the need for climate change and regulatory change, I think the bar for that liability should be high, and the bar for damages should be high as well. There should be truly an arbitrary conduct that shocks the conscience. A mere change in regulation and frustration of the investor's expectations should not be enough. And damages should be proven in detail. Now, this is particularly relevant because given the impact of climate change and widely known efforts to combat it, climate change regulations are absolutely foreseeable now. The general rule in ISDS, of course, is that absent an express stabilization agreement, no investor has a legitimate expectation that a state's laws and regulations will remain the same. With respect to climate change, we can go even further. Investors are on notice that states have an affirmative duty to combat climate change and implement national legislation that reduces emissions and prevents further environmental deterioration. This should impact liability. For example, the tribunal should ask whether an investor has assumed risk in light of this foreseeability. If I'm an international investor in this climate and I decide to invest in a carbon-based energy plant, there are certain risks that I'm assuming here, given the likelihood of environmental changes, and that should be taken into account. Other questions are, has the investor conducted sufficient due diligence? Are its expectations reasonable and legitimate? And these concerns also affect quantum. For example, did the investor mitigate any foreseeable risk of loss? Now, we see these considerations regarding foreseeability in another case, RWE v. Netherlands, another ICSID arbitration case under the Energy Charter Treaty, arising from a state's implementation of a phase-out of coal-based energy. The arbitration was ultimately discontinued when Netherlands, the respondent, went to German courts and obtained an anti-arbitration declaration because of the intra-EU nature of the claim. Now, as many of you know, under the ACMEA decision, states within the European Union cannot sue each other under the Energy Charter Treaty, at least. There have been decisions with respect to that. Some tribunals have ignored that decision and interpreted it another way. Now, the Dutch courts subsequently heard the dispute and found that there was no expropriation, and that considering the foreseeability of a governmental intervention to cut CO2 emissions, the duration of the phase-out period, which was well known, and other circumstances, the measures were proportional, and therefore there had been no breach of the European Convention on Human Rights or the EU Charter. Now, this was a national court, And the question I have is whether an ISDS tribunal would take into account the same considerations. And my concern is that perhaps it would not. And one of the questions I have is whether or not sometimes these issues might be better left for national courts that better understand the sensibilities involving climate change. But I leave that question for further debate and discussion. Now, with respect to damages, the additional complication is that generally cases involving environmental measures arise in complicated sectors: mining, energy, oil, and gas. These involve complex projects and valuations. The determination of causation is often complicated because a project's losses can derive from various factors, often in parallel. So, for example, if I'm losing money as someone in the oil and gas industry, what is the driver of that loss? Is it the falling oil demand? Is it falling oil prices, or is it state regulation? How do you differentiate among those potential causes? And well, of course, this is where the damages experts come in. They'll have an important role in this, particularly when they develop their but-for scenarios. These but-for scenarios should make sure that the environmental regulations are isolated so that the impact of other forces are not artificially removed, thus inflating the valuation. Experts should be able to rely on market data to make these isolations, but in certain situations, they may need support of other technical experts. Now, development evaluation models must also consider other important factors. For example, in the AET Germany case, which I mentioned earlier, the pending arbitration regarding the coal-based power plant, claimants have submitted a DCF valuation. Germany has attacked that valuation, alleging that it is flawed because it fails to use Paris Agreement compliant input data in its but-for scenario. Specifically, Germany alleges that its expert damages valuation includes low CO2 certificate costs, which are not consistent with Paris Agreement obligations to limit global warming to 1.5 degrees Celsius, and thus artificially inflates claimants' damages. Other inputs which Germany says should be included are development plans that include renewable expansion and battery capacities. The question is, should but-for scenarios be developed that are consistent with existing international obligations, and presumably national laws that implement those obligations? And I would argue strongly, yes, because these obligations would remain constant under any scenario, with or without the disputed measure. Tribunals should ensure that damages evaluation include considerations for mitigation and contributory negligence as well. In the same AET case versus Germany, for example, an issue in dispute is whether AET could convert the coal-based power plant to run on gas fuel, and what obligation it has to mitigate damages. To further explore the complexities involved in the valuation of investment impacted by climate change measures, I'd like to look at Eco Oro v. Colombia, which I'm sure many of you are familiar with too. This is a long-standing case. A Canadian investor, Eco Oro, commenced an arbitration against Colombia for more than $760 million as a result of regulatory changes that impacted its concession for the exploration and exploitation of gold and silver deposits in an environmentally sensitive, high-altitude wetland zone known as Paramo, or as the Paramo. In 2010, after Eco Oro had entered into the concession agreement, Colombia enacted a law prohibiting mining activities in the Paramo, which contained approximately 54% of the concession area. This required Eco Oro to redesign its planned mining operation. It was an open pit mine. It would now have to go underground, and submit a new environmental impact assessment. An attempt to provide for an exception to the 2010 law to permit Eco Oro's project was struck down by the Colombian Constitutional Court, as was an attempt to delineate the Paramo so that they could clearly define what areas were outside of the protected area. The issue about the delineation of the Paramo continues to be open. It was never delineated. In fact, to this date, no final delineation has been established. And ultimately, the Colombian Regulatory Authority refused to approve additional suspensions of obligations, which had been given during several years under the concession, and Eco Oro renounced its concession rights and commenced the arbitration under the Canada-Colombia Free Trade Agreement. Now, an initial decision on jurisdiction and liability, the tribunal rejected Colombia's jurisdictional objections and held that the environmental measures carve-out in the FTA was inapplicable. The tribunal determined that the language in the exclusion or the carve-out was only permissive in nature. It simply preserved the state's right to implement environmental measures, but did not mean that it was exempt from liability for those measures. And in that sense, it raises the first flag I want to raise here, which is the intent or the understood intent of a lot of these carve-out is precisely to limit liability of the states with respect to environmental obligations. And this is an example of how tribunal interpretations sometimes undermine that intention. Now, a majority of the tribunal made up of the president and respondents appointed arbitrator, again, Philippe Sands, determined that Colombia's actions were expropriatory, but that it amounted to the lawful use of its police power, and thus did not engender state responsibility. The third arbitrator dissented from this decision. A separate majority, the president, this time with the claimant's appointed arbitrator, found, however, that Colombia's inconsistent approach to the delineation of the páramo and the fact that it hadn't done so violated claimants' legitimate expectations and failed to provide a predictable regulatory environment, and thus violated the minimum standard of treatment. The state-appointed arbitrator dissented from that decision. The tribunal reserved its decision on damages, provided guidance to the parties indicating that it believed that the comparable transaction methodology would be the most appropriate because there wasn't a history of operations. And asked specifically for certain comparables. Claimant had given a certain types of companies that were comparable. Colombia had given others, and the tribunal specifically asked for certain comparables. It also expressly noted that because Eco Oro would still need further permits to commence operations, a question arose as to whether Eco Oro's loss should be limited to the value of the lost opportunity to apply for an environmental license. The tribunal requested additional submissions on these and other questions, including how to value the loss of opportunity, whether Eco Oro had conducted proper due diligence before it changed its planned mining operations, the proper valuation date, and whether the losses suffered by Eco Oro due to the minimum standard of treatment breach was the same or different than the loss suffered for the expropriatory conduct. And that becomes relevant later on. Because in its final award, the tribunal split once again. The president and respondents appointed arbitrator found that because the expropriation was lawful and conducted in furtherance of the state's police powers, claimant could not claim any damages for this breach. Claimant was thus not entitled to cover the full value of the concession. Instead, it could only seek compensation for the loss of its opportunity to claim an environmental license. However, claimant failed to provide this valuation. It provided the comparables requested by the tribunal, but only for the full value of the project. Absent sufficient input from claimant, which had the burden of proof, the tribunal could not grant damages and declared so, that there were no damages. Now, several takeaways here. First, the case highlights the complexity of issues involved in these matters. Several years, several rounds of pleadings, several questions raised with respect to damages and valuation. It demonstrates the limitations on treaty carve-outs, as I mentioned, and how they can be nullified by tribunal interpretation. There is some deference to states' police powers in connection with the expropriation claim, but perhaps an inadequate consideration of issues involving assumption of risk by claimant in connection with the minimum standard of treatment. In this regard, there was evidence that Eco Oro commenced its investment at a time when concern about greenhouse gases was already a prominent issue, when it was known that the páramo was a sensitive environmental area and regulations had begun to be implemented in Colombia. Should that have been considered, is my question. Now, with respect to damages, issues of mitigation were left unaddressed. The case also demonstrates the pitfalls of insisting on a higher valuation for the entire investment. Oftentimes, the argument is made that the valuation for an expropriation and minimum standard of treatment, or FET, are the same, but that's not the case. And here, the tribunal expressly warned that this would be an issue. Because no valuation was presented, no damages were awarded. Now, this award is currently subject to an annulment proceeding, so we'll see what happens. It may be that Eco Oro saga will continue. What will be interesting to see is if there's a second arbitration, whether the outcome will be any different in light of the recent ICJ advisory opinion on the obligation of states in respect of climate change, which was issued in July 23rd of this year. And I'll go over the advisory opinion. First, let's take a moment to understand the import and significance of the advisory opinion as a reflection of the international community. The request for an advisory opinion was submitted by the General Assembly, which adopted the resolution by consensus. No objections. Spearheaded by Vanuatu, the resolution received widespread support with over 130 countries of the total 193 member states of the UN, co-sponsoring the resolution before its adoption. The questions presented to the ICJ were as follows, and here I'm quoting, what are the obligations of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases for states and for present and future generations? B, what are the legal consequences under these obligations for states where they, by their acts and omissions, have caused significant harm to the climate system and other parts of the environment with respect to states, including small developing states, and peoples and individuals affected by the adverse effects of climate change? Now, a record 91 states submitted written submissions to the ICJ. 96 states presented oral statements, and multiple international organizations participated in the proceeding as well. Now, many believe that the ICJ might thread the needle on some of these issues, presenting a middle ground that reflected the competing interests and positions presented. But the ICJ issued a bold and far-reaching opinion that was adopted unanimously by the court's 15 judges, a rare feat and reflective of the desire to give this opinion persuasive authority and political legitimacy. The ICJ held that the customary duty to prevent significant harm to the environment applies fully to the climate system. Crucially, this duty applies to all states, including those that are not parties to climate change treaties. The ICJ, as Sara mentioned, also rejected the argument that climate change treaties constitute lex specialis and thus render other rules of international law inapplicable. The ICJ found no inconsistency between the treaties and other relevant rules and principles of international law, and thus found that the treaties operated within rather than outside the international legal system. As Sara said, a holistic view of international law. Significantly, the court articulated a stringent due diligence standard. In light of the scientific consensus, states must act urgently. This includes not only setting and updating robust national climate plans under the Paris Agreement, but also regulating private actors and providing support to more vulnerable nations. The ICJ affirmed that failure of a state to take appropriate action to protect the climate system from greenhouse gas emissions, including through fossil fuel production, fossil fuel consumption, the granting of fossil fuel exploration licenses, or the provision of fossil fuel subsidies, may constitute an internationally wrongful act which is attributable to the state. When a state fails to meet its international obligations related to climate change, whether under treaty or customary international law or human rights law, it incurs responsibility under the law of state responsibility, triggering a panoply of legal consequences. And these can include cessation and non-repetition. They have to stop with the harmful conduct, full reparation, including restitution to the harmed state or persons, compensation for financially accessible damages, and/or satisfaction for moral or non-material harm. The advisory opinion's full impact is yet to be determined. It just came out in July, but it's clear and unequivocal. And because of the interactions of states' climate change obligations with that of investment protection under the investment treaties, there will likely be much more said about it in future investment arbitration awards. The advisory opinion, in my view, should induce arbitrators to give proper weight to a state's police power vis-a-vis the environment. It should make tribunals interpret treaty carve-outs for environmental measures much more carefully, at a minimum as a supplementary tool of treaty interpretation. It also, of course, further underscores the foreseeability of environmental regulation and potential assumption of risks of investors. When it comes to damages, it should also induce arbitrators to examine carefully what assumptions are being made, what inputs are being included in the valuation, and what but-for scenarios are being presented. I will say this, tribunals have surprised me before. Recall the echo-oral minimization of the treaty carve-out in that case, which I mentioned earlier, and the controversial Rockhopper case. So we'll have to see if the advisory opinion is given the weight it properly deserves. I, at least, am cautiously optimistic. And with that, I end. Thank you very much.
Thank you very much, Ken, for this very interesting overview of these important cases and the potential impact of the ICJ's advisory opinion. We now move to the more practical questions of damages assessment. And in this segment, we would like to analyze a few questions, including which methods, whether DCF, comparables, replacement costs, are the most appropriate for valuing stranded fossil fuel assets, or how to deal with data limitations when projecting energy market risks tied to climate policy, how to incorporate carbon pricing, changing demand, and global transition scenarios into valuation models, how to construct a but-for world for coal or oil projects, assuming business as usual or factoring in early closure trends, or how to embed legally backed climate obligations into discount rates, risk premiums, scenario analysis, including treating regulatory intervention as a certainty rather than a contingency. And I invite our experts today to share their insights on these questions, starting with the first question of what is the appropriate valuation model methodology for stranded assets?
Thank you, Sarah. I'll take a first stab at this and pass it over to Glenn. I think obviously it goes without saying, any method needs to be determined based on the facts of your specific case. I think as Ken mentioned a number of times, DCFs are sometimes or often rejected when there's no history of operations. But the DCF in general allows for the most flexibility when considering climate change impacts and the various inputs that you would need to consider. Also, I think as much as market ways of valuing with comparable transactions or comparable companies are liked and easy to understand, there is oftentimes you have a very difficult time finding companies that are going to be truly comparable to what you're valuing, especially I think with regard to this specific topic when you're talking about different states and different countries having different regulatory requirements or offering different subsidies. So it's really important to make sure you're in your comparables that you're aligning with companies that are truly comparable and facing the same risks and benefits or costs that your subject company is facing. I'll turn it over to you now. Go ahead.
Thank you, Laura. So as a preliminary matter, I think it's worth saying a couple of comments about the big picture, building off of Kenneth's very eloquent introductory comments. The beauty of being a quantum expert, if there is any beauty involved at all, is that we don't argue cases, we don't decide cases, we take instructions. And we, of course, have a body of methodologies and ethics and approaches, but in the end, we need to choose those methodologies and approaches, including whether we use DCF or comparables or replacement cost. We need to make that selection based on, ultimately, on good practice and instruction from counsel. We can afford, in fact, we are compelled to be agnostic regarding the political, legal, and regulatory framework in which these ISDS cases and other cases are argued. And so I agree completely then with Laura that the facts and circumstances within a particular case would suggest which of those three basic methodologies would be appropriate. I think first of all, I think that wherever possible, it's incumbent on the quantum expert to apply all three if possible, and then to compare and contrast the results and ultimately alight on the methodology which is the most reliable. What makes something reliable? It's repeatable, it's transparent, the assumptions are very clear, it's internally consistent. I would agree that generally speaking, the DCF methodology for an operating asset, an income producing cash flow, and one hopes net income producing asset is frequently the most reliable. On the other hand, if a project or business or asset does not have an operating history, then one of the other methodologies would typically need to be selected, including, and this is the topic for the next panel, including sunk cost in many instances.
Thank you. Thank you. So how would you deal then with data limitations when projecting energy market risks tied to climate policy?
Well, I think in any case, when you have data limitations, you have to, in some cases, reassess. So this was something that both Glenn and I were alluding to. Sometimes you might wish to do a DCF, but the data that's available, the limitations on that data just don't allow for that to be the case. Or the same can be true of your market approach. If you have data limitations just by the sheer fact that you don't have true comparable companies, those things are all going to impact what you say. You consider all of the approaches, but ultimately, what ones can you actually utilize and do so in a manner that is going to be reasonable for a tribunal to ultimately award damages. I do think that, sometimes we need to think a little bit outside the box as to where the data sources are that we can look at. And I think in a topic area such as this, that's so new and important, not that new, I guess, according to Ken, but that's really on the minds of people today and tribunals and regulatory bodies, there is a lot of data being gathered on it, and some of it you can see being built into your market reports that you would be using to make projections or to confirm projections. Assessing whether your costs are going to increase because of compliance concerns, whether there are subsidies that are being offered for greener energy, things to that nature that you can sort of look at a little bit further than you might normally in an environment where these things aren't as big of a concern, in order to assess what the future really does look like at the time of your valuation.
All very good and sound approaches. The only thing I would add is that frequently the kind of data we're talking about here would be a projection made by the International Energy Agency or the national government in the jurisdiction in which the case arises of future something, oil or gas prices, future electric power prices, so various commodity input and output prices, which can then be used in a damages model. And the challenge that we as quantum experts face then in using that data, so those projections, is that typically they're very transparent and typically, or frequently anyway, quite reliable in the near term, 1, 2, 3 years, some period of time. And then after that, they simply, maybe they have different scenarios, but frequently the base case is business as usual. We'll escalate at some kind of assumed inflation rate or something like that. And the real challenge we will face, increasingly face, in light of the ICJ advisory opinion, is squaring those projections, those data sets, with Ken's, I think, very well articulated view of some of the obligations and therefore risks that energy and mining and infrastructure projects face going forward. I dare say whatever the political, legal, regulatory preferences of any of us or any of our national governments in this room, or we as individual experts or lawyers arguing cases or arbitrators deciding cases, it will look very different going forward than these assumptions and basic scenarios which have long been baked into these data sets.
So if I could just jump in here, because one of the things that came up in like the Echo Auto case and others is a debate as to the valuation date, right? Whether you do ex ante or ex post. And with respect to this issue of limitations of data, wouldn't it be advisable, and I guess under what circumstances is it advisable to do an ex post analysis? We can actually incorporate some of this data sets that you wouldn't have in a projection versus ex ante.
Yeah, I think this is an important point, and just to, I don't want to assume everyone knows what ex ante and ex post mean, but an ex ante approach is what you would typically see under evaluation is where you're going back to the date of harm. Your valuation is done that way, discounted back to that date, and it assumes only information that was known or knowable at the time of the valuation. Whereas an ex post approach, which is what Ken is suggesting, or even there have been cases where even hybrids approaches have been used, and I'll discuss that in just a second. But the ex post approach takes you to the date of the hearing or an estimated date near the hearing, and you can value or take into account information that is known up until that time, so as current as possible. So I think there's a balancing act that has to happen, because a lot of times tribunals will allow for the consideration of that information if it's in a balanced approach. But if it's not something that an investor would have considered at the time of the breach, at the time of the valuation, they're going to weigh sort of the benefit versus the loss. So that's one thing to consider. And a hybrid approach, I've used this in a case before, which is basically it's taking into account information that allows you to make better projections or to tailor your projections, knowing what sort of has happened in the economic environment, but you're still discounting back to the date of your evaluation to take into account that they are still in fact projections. So that kind of allows for the additional knowledge that you can gain by the passage of time and the changes that are occurring, but still taking into account some level of risk that these are it's still a but-for world, right? It's still a world that never happened for your subject company, so.
I agree with all that, and would add only that I'm firmly in the ex ante, not the ex post world, because investors can't be held to a higher standard than the rest of us with the foreseeability of the future. They don't have crystal balls, and even if a very broad legal framework like the ICJ advisory opinion is handed down, actualizing that into something meaningful is quite challenging. So I think for reliability, whenever possible, I would prefer to stick with the ex ante approach.
I also agree with that, but I will say, and typically what I've seen when studying this issue is that the cases where an ex post approach is allowed, it is actually usually only allowed when it benefits the investor. So it is a situation where the investor would have benefited by that additional information had it been known. Whereas I think in the case of what we're really talking about today with climate change and increased regulations and stuff like that, most likely it's not going to benefit the investor, especially in non-green energy spaces.
So my next question that I had, I think it's been partially responded, but maybe you want to add some additional comments, is how to incorporate carbon pricing, changing demand, and global transition scenarios. Here, the example of the data of the International Energy Agency or the IPCC data into valuation models. I don't know if you want to add anything to what you already said.
Sure, we'll change up the order of responding. I do think we've addressed a fair amount of this topic already, but the one thing I would add is that the challenge that quantum experts face in articulating these scenarios. So we're superimposing, in a sense, a but-for scenario of an investment with various scenarios of global climate change and national responses to global climate change and to their own view of their obligations pursuant to international treaties to mitigate global climate change. And so we could potentially end up in a very complex world where we have multiple sort of business-oriented, asset-oriented but-for scenarios, and then looking at those through the lens of multiple global climate change and national policy but-for scenarios. And if there's one watchword for quantum experts, it is simplify. The notion of a model is to simplify the world. And so, and there's no easy answer here, but I think one of the things that Laura, perhaps certainly I will be thinking about in the coming years and decades will be how to simplify our analysis in light of this, hugely complicating factor of national obligations to mitigate climate change. What does that mean? How does that get actualized within a damages calculational framework? And keeping it simple will not be easy.
Yeah, I agree with that. I think, when you typically start evaluation, you're looking at how the past has performed, and when the past isn't really necessarily instructive anymore, it leads you to, well, how do I deal with that? And I think, as we continue on, there'll be more information to consider whether you're, looking at somewhere maybe with a different jurisdiction and performance of, some of the countries that are a little bit ahead of the curve on some of these things, or you're looking at what I think, Ken mentioned bringing in technical experts. I think that's very important when you're dealing with an environment where, the past, and not just the past of your subject company, but the past of sort of the industry as a whole, or the pricing as a whole, or demand as a whole, is no longer necessarily instructive. It's really important to make sure you have the right technical expertise to assist as a valuation and quantum expert.
So in the spirit of simplifying, so how do you construct a but-for scenario for an ongoing, operating oil or coal power plant? Do you assume business as usual on one extreme, or do you factor in early closure trends or as early closure?
So in the absence of instructions from counsel to the contrary, the traditional, tried and true, and I believe reliable approach among quantum experts is to make, along this dimension, two basic assumptions. One is that the national law is the national law, and we can't predict the future of how the national law will be changed to reflect the ICJ advisory opinion or anything else for that matter. And secondly, that actors will comply with the national law as it stood at the time the damages or alleged damage took place. So that's the traditional way to do it. What I'm hearing from Ken is maybe going forward, there may need to be instructions which would differ a bit from the traditional approach, but that is the traditional approach. And so in the absence of instructions to the contrary, that's what I would do.
Yeah, no, I would definitely agree with that. And I think the one thing I think even as you're doing that instruction, the kind of the counterpoint is what is the market reports, industry reports, what are they projecting sort of the future will look like under, knowledge of these things. So if you're sitting into a time of today and you're doing your, your valuation as of today, what do the industry researchers, what do, if you're in oil and gas, what are the market reports how are they talking about demand in your specific area? Are they planning that demand is going to decline? Are they continuing business as normal? Do they don't think that, how are the regulatory environments going to impact that? And then, of course, I think on the opposite side of dealing with your cash flows and things, you also need to consider if you can account for some of the risk through your discounting. Is there a risk that is the risk that you're not going to achieve a business as usual higher than it was 5-10 years ago? And I know I'm jumping. I don't want to jump ahead to the next question, spoil it for you. But I think as damages experts, it's really hard for us to support, adding just random premiums to discount rates without, evidence behind that. Tribunals really don't like it. And I think whether they don't like it because they don't like discount rates, as a fellow lawyer, I know you like them, but most lawyers I know really hate that kind of stuff. So I don't know if it's that, or if they really just want to be able to see something a little more concrete.
So Ken, a question for you then. So how do you embed these legally backed climate obligations into discount rates, risks premiums, and scenario analysis?
I mean, I guess it will depend on a case-by-case basis, but I think for example, the example I gave in the Germany case, ATV Germany, is a good one. In that case, there's a national system of certificates for carbon emissions, right? And there's certain pricing for them, right? And so there's something concrete in the law. There's a market for it. There's a value for it, right? And I think, and the critique, and this is still, these are just the pleadings, which are public, right? So we don't know what the tribunal is going to decide. But the critique is, and take it for what it's worth, either the tribunal will decide in favor or against, that the claimant's valuation fails to take into account for the proper pricing of carbon emissions, taking into account the Paris Accord obligations, right? So they can't just assume, oh, I'm going to get all these, these carbon emission certificates because it's going to be limited. And so that has an effect on the valuation. So I think those kind of things, those very concrete, I agree, it's very hard to kind of come up, and I think a tribunal will reject coming up with speculative kind of instructions and theories as to, well, this may change this. But I think if you have something that's concrete already, and what's going on is a lot of states are implementing their climate change obligations into national laws. And once you have that and you can point to concrete evidence of that, I think those factors should be implemented, should be included in any kind of discounts or other form of methodology.
I would mention that there are some countries which are not embedding their climate change obligations into national law. And so one is left wondering, in a world of countries ignoring their climate obligations, what does the expert do? And I'm a fan of scenario analysis. I mean, back to the question of, there are different ways of dealing with these risks. And I think where you were going, Laura, is that the word you use is random as a modifier for discount rate. But whether it's random or carefully thought through, the problem with modifying a discount rate to reflect risk for a fairly unspecified set of outcomes is that a tiny little change in a discount rate can turn into billions of dollars of value over the discounting period, which probably is decades. And so frequently, if not typically, wouldn't say without exception, but maybe we're getting close to that, simply modifying a discount rate to reflect some kind of perceived risk can be a very problematic way to address or capture those risks in a valuation exercise, and more typically explicitly articulating scenarios and play out what the scenario would entail in terms of costs and revenue but yeah, possibly a discount rate, but just don't blob it all into a discount rate change is typically my modus operandi when approaching these things.
Yeah, I would just agree. I think if you need to be able to have like as much concrete evidence as you can to assess adding any additional risk to your discount rate. In my experience, tribunals are very hesitant to do that because of the impact that you exactly pointed out, Glenn, is you think, oh, it's just 1 percentage point, but 1 percentage point on a large claim has a huge impact. So especially, you know, when you're talking about you're valuing something into perpetuity, that value, you know, it continues, and so the impact is quite large. I do think that you know, something that needs to be considered is whether or not you can see increased risk in your industry over time, since these kind of issues started to come up. Has the industry, oil and gas industry, become more risky when you're looking at sort of betas over time, that you can see, okay, yeah, I'm not having to add anything because, or I'm not going to add anything because I think in general, the markets, the industry's risk is increasing, and it has been increasing since the beginning of this sort of idea. But I also agree with you that in some countries, when the regulatory environment changes with every leadership change, like here in the United States, for instance, that risk can get really high, right? Because in set of 4 years, you have a president that's like drill, 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 and then you have another president that's like no, 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 solar, solar, solar. So it really just, I think, depends on the circumstances in the industry and the national environment you're operating in.
Thank you very much for this very insightful discussion. Before we move to the Q&A, I want to make sure that David has a few minutes to present in a related topic, the campaign for greener arbitrations, and then we'll move to Q&A.
Yeah, thank you. Thank you. Yes, so I'm representing the campaign for greener arbitrations, and while the work of the campaign does not necessarily fall directly under the topic of valuation, it deals with a central theme that has been mentioned throughout the panel, which is the direction towards scaling back the carbon footprint of by states, and you mentioned, several panelists mentioned the advisory opinion of the ICJ, and also I think our own obligation as arbitration practitioners to also scale back and attempt to scale back our carbon footprint. So to talk a little bit about the work of the campaign for greener arbitration. It is essentially, I want to make sure I have this here. What is the campaign? It is an initiative to reduce the environmental impact of international arbitrations. The campaign was founded by Lucy Greenwood in 2019 with the aim of significantly reducing the carbon footprint of the arbitration community. Over the last 6 years, it's evolved into a campaign for our arbitration actors, institutions, arbitrators, law firms, hearing venues, and there have been various initiatives that have developed within it. One of those is the Green Pledge, which we'll at the end of this presentation invite you to find and to sign if you haven't already, either on behalf of yourselves as arbitration practitioners or on behalf of your organizations. But also it's developed into a set of protocols that provide sort of best practices for all of us to adopt. So, to discuss some of those protocols, and I'll be very brief about this because we have a very interesting Q&A to get to. These are a set of practices that, including creating workspaces with reduced energy use and waste, corresponding electronically unless hard copies are essential, using video conferencing instead of travel for meetings or witness work, essentially taking these best practices that will help all of us reduce our carbon footprint when we're engaging in arbitration proceedings. I want to discuss an exciting initiative that is being launched and developed and launched by the campaign, which is called the Carbon Impact Model. And this is essentially a tool, an online tool that is not yet available, but we are developing, which will allow arbitration practitioners to enter information about a given set of proceedings and will enable us to measure our carbon footprint and the carbon footprint of a given arbitration proceeding. How does this relate, to valuation? We don't know yet, but it could be something used by arbitral institutions, arbitral tribunals to assess the actual, the emissions created by us as practitioners. And I think it is relevant to as we're discussing arbitrating and adjudicating questions, substantive claims that arise out of obligations of either actors in certain state environments or states to reduce their carbon footprint. So I think, to me, it sounds like it's a matter of integrity. If we are arbitrating these issues, we should also be implementing the practices that reflect the things that we're trying to enforce or we're trying to argue. So without getting too deep into it, the carbon impact model will be an online tool that will be accessible eventually through the website of Campaign for Greener Arbitrations, in which practitioners will be able to input information about the proceedings, and that information would be like the number of arbitrators, how much travel is involved, the preparation leading up to the arbitration. So if there's been lots of traveling to see witnesses and interview witnesses, the amount of printing, all these different data points, and it'll allow you to measure and have a sort of understanding of your own carbon footprint. And I think that will be something that could be useful later on as we are moving into a world where carbon emissions are consideration in everything we do. So yeah, I think I want to make sure I'm actually flipping forward on the right thing. Yes. Essentially, so in terms of, I'll just conclude by saying that if you haven't yet signed up for the Campaign for Greener Arbitrations, please visit our website at greenerarbitrations.com, where you can read the pledge, and if you want to sign up, you can sign yourself up, or you can talk to your organization about signing up. And also keep an eye out for the carbon impact model that we'll be releasing. Thank you very much.
Thank you so much, David, for this important initiative. I'm happy to report that ICSID, before the pandemic, but it was accelerated by the pandemic, we've gone paperless and very green, and we have members of Counsel at ICSID that are members of this campaign. And so I think we're all moving in the right direction, and I see a change in the attitude of the arbitrators and the parties that 10 years ago was impossible, like people saying, well, do we really need to travel for this? And they're, I know, not only thinking about the expenses, but the environment as well. Anyway, so then opening now the floor for questions.
I have a question for Ken or Laura or Glenn. If we take into account the set of advisory opinions that have come out, not only by the ICJ but also by ITLOS and also by the Inter-American the Inter-American Court of Human Rights, that touch upon climate change. If there is compliance, or if those states, depending on whether they're part of the Inter-American Human Rights system, or whether they're part of ITLOS, or whether they're part of the world, if they take those advisory opinions seriously, then in principle that should lead to some regulatory changes for taking into account climate change. I mean, at least that's what those opinions provide and say, and that would, in principle and possible, have an impact on some premium or country risk or some sort of setting there. So that's the first question that I guess that would mostly go for the quantum experts. And for Ken, for those states that are heavily involved in investor-state arbitration, my thought, and I don't know whether you would agree, is they would be better off by implementing those obligations of climate change, or by creating some set of rules of implementation of climate change rules. The opinions don't say do this because it's a matter of local law, but the issue of not implementing might leave them at a worse place, given Glenn's comments that, well, not everyone is really implementing. So if you really have a defensive perspective in investor arbitration, but also not only there, but in general terms in international litigation, you might be better off by saying, okay, what are my obligations? Am I implementing them? And if I am doing so, then that might have an impact once you're calculating quantum. Because if you don't implement, the quantum expert won't be able to take that into account. But if you are, then guess what? Here's the law. This is how we're doing it. So I'm wondering whether there's any comments from both ends, counsel and quantum experts, in the reverse order. Thank you.
Yeah, I mean, I think for us, it's, what kind of environment are we dealing with at the time of the valuation, and how can we model that in? I think, in a general sense, if you're, required to meet certain compliance obligations under the, suggested, or the, not suggested, but the new laws that you're sort of mentioning that might come into play, then, you need to be able to model the cost of being in compliance as part of your operating expenses on the asset. I do think that adding, to reiterate, I think adding premiums to discounts without enough data to support is still something that tribunals are not ready for. And so I think that the more concrete you can model things into your actual cash flows are going to be better taken by an arbitrating panel.
The thought I would add to that is that we are describing here today really three levels of reality, if I could call this, regarding climate change and how national obligations can flow through to damages in international disputes. And on the one level is the ICJ advisory opinion, with now national governments having an obligation, a customary obligation under international law to do something. Then we have national laws, which may or may not reflect that obligation. And we have, as quantum experts, we also need to consider, again, depending on the particular case and the instructions we receive, the actual behaviors of people. And speaking as a PhD economist, we have this world of revealed preferences. And I dare say, both in this country and in a lot of other countries, the revealed preference of a very large fraction of the global population is to ignore the ICJ advisory opinion, and in some instances to ignore whatever national policies may be pushing toward carbon emissions reductions, and to continue with life as usual. And so, which involves looking around at the world of cars and planes and emissions from human activities galore without an end in sight. We have our work cut out for us, determining which of those three levels we take as kind of a given when we sit down with a sheet of paper or with an Excel spreadsheet and begin calculating damages. It's not picking any one of the three in a vacuum is probably fraught with peril.
So I'll answer the second question. I think that I agree with you wholeheartedly. I think that particularly for developing countries, I think it's the effect of the ICJ advisory opinion, the effect of the advisory opinion by the Inter-American Court on Human Rights and of ITLOS. Essentially, what they do is they make it clear that that this is now an obligation, right? So it provides some cover and legitimacy to a lot of changes that have been happening. In my experience, at least, in Europe, there are phase outs, their laws have been passed to phase out coal. In Latin America, there have been various attempts to implement, halting certain mining activities near environmentally sensitive areas. So I think in my experience, most states are implementing or want to implement these environmental changes. There's also like political support for that, particularly within the local communities. I think most of the people who aren't implementing it, unfortunately, are the big carbon emitters, right? Like the United States. And in that case, then that does become an issue. But then I guess, that's something for the, if there's ever a demand against a US company, what would happen? I'm trying to figure out like what that would look like. But in most situations, you're going to find a foreign investor in a developing country where there has been an implementation or there should be an implementation of these obligations. And so I think that you're absolutely right. I think if you are a state, now you have various decisions that are telling you this is not just, it's not just discretionary. It's actually an obligation. And so that provides you a certain kind of cover that says, I changed this regulation because I'm obligated to do so. And that should translate into, ideally for tribunals, a proper analysis with respect to liability and damages along the lines I was saying. So 100% agree with you. One thing just to add some, a question, and I don't know, but in terms of premiums and things like that with that question, in some respects, could we, let's take a look at telecommunications, right? There were often changes in technology, right? Where one technology was fading away, 4G and then to 5G. And so if you're a 5G investor, you would price that in as a premium, as a risk, right? If you come in as 5G is becoming the norm, and you come in at 4G, you would be able to calculate that premium, right? So why couldn't we do that for, let's say, fossil fuels in a general case? There's a general consensus among the international community that we should limit those over time, right? And I think Sara mentioned a particular date under international obligations. So why couldn't we price it the same way as we do with other sectors?
It's a good question. I think in a general sense, the inconsistency across geographical regions on these things doesn't lend itself to make those kind of calculations. I think when you're talking about sort of telecom as example, and definitely there are areas, geographical areas that are the leaders in implementing the changes between 4G and 5G and so on. And also historically, you can go back even if your subject company has been around long enough, and you can look at how they performed through those transitions, as opposed to sort of this more of an unknown and where there's little to no consistency between geographical regions, as opposed to, telecom's a little more predictable. You have certain countries that are going to be the leaders in the changes of technology, and then you have your followers at a slower pace. So.
I would agree with what Laura said and add that even when a country decides to implement in a national law its obligations to mitigate climate change, international obligations, it can choose policy levers which can have very different impacts on the damages calculation. So for example, a very simple example would be in the world of carbon emissions from power plants, there's frequently or typically a choice between a cap and trade scheme and a carbon tax, where the cap and trade scheme yields a known quantity reduction but an unknown effect on price, whereas a carbon tax is a known impact on price with an indeterminate impact on emissions quantities on Q. And so even something as simple as that, you know, are you fixing P with an unknown Q or fixing Q with an unknown P? Even if a country takes very seriously its international obligations, the quantum expert may be left guessing as to what mechanism will be selected. And it just makes it hard. However desirable, it's just really hard.
Whether countries could use this international obligation as an excuse so that they could, to get out of commitments they've made to companies that want to develop their resources.
Yeah, I mean, I think, as I said, right, I don't think anyone is arguing that there should be no responsibility of states to investors, right? The investment treaties exist to promote investment, to protect investment. But I think I think the thrust of what I'm trying to say is that there has to be a more careful analysis with respect, particularly with these new obligations. There could be a bad state actor that uses these obligations as an excuse and just decides to arbitrarily, shut down all operations without much justification. But if that's the case, in an arbitration, one would be able to establish that, right? One could argue, there hasn't been justification for these particular measures. These particular measures are extremely arbitrary and extreme. And I think that these are just a pretext, because really what they're going after are, let's say, investors of a particular nationality, right? And then in those situations, yes, and investment arbitration jurisprudence, I think, would support an argument to say, in that situation, there should be state liability for the investor and there should be compensation. What I'm trying to, I guess, what I've seen a lot is sometimes tribunals have tended to permit compensation on just a change of regulation sometimes, not all the time, but sometimes there's a change of regulation without necessarily any animus or any kind of pretext, a change of regulation, but that somehow affected the investor's expectation, right? And that has been enough for some cases, not all. And what I'm saying is that now with these obligations that are internationally recognized, what I'm saying is that in those situations, maybe there should be a higher standard. There should be something like proof of discrimination, of arbitrariness, that kind of stuff.
Okay, so I'm afraid we've ran out of time. So I want to thank our panelists for this very thoughtful conversation on this very important topic in the current context of transition, climate transition, and also in a context where some voices have raised concerns about the role of what is the role of ISDS in this transition. So I think it's very important for economists and lawyers to talk together, and I hope that to discuss, and I hope that the conversation will continue beyond this room. So please join me in thanking all the panelists today.